All right. Back.
Babylon a old, them a old vampires, bloodsuckers. Babylon a try hold me down for more than 400 years. But I overcome and conquered all my fears. Them a try hold me down for more than 400 years. But I overcome and conquered the wills and tears. So long we be working in them system, and still they don't give a damn
how you
living. God forbid sickness as it is, we've got to fight. And in the midst of adversities, we struggle to survive. Babylon and try hold me down for more than 400 years. But I overcome and conquered all the fears. Them a try hold me down for more than 400 years, but I overcome and conquered all of fears. They thought that they could wipe us out, and they carried us to enslave us, east, west, north, and south, giving us bad food to eat, and having no decent place for us to sleep. But by the powers of the Most High, who guides and keeps His children, keep on moving through the valleys deep. Still Babylon I try hold me down for more than 400 years. But I overcome and conquered all my fears. Babylon I hold me down for more than 400 years. But I overcome and conquered the ways and tears. Hey, them old vampires, old bloodsuckers, sucking the blood of the poor and the needy. Babylon, old vampires, old bloodsuckers, they've been sucking up the blood of the poor, drawing out the veins of the poor and needy. So we can wanna try hold me down for more than 400 years. But I overcome and conquer all their fears. Babylon, I hold me down for more than 400 years. But I overcome and conquer all the fears. Babylon, I hold me down. And I hold me down for too long, too long, too long now. We must rebel against this wicked system. They've been holding us back for far too long. Wicked man, try hold me down for more than 400 years.
Yo, mic check. Okay. All right, my mic sound nice. As you can see, I tried to get started earlier. I got clipped. I had to double back and come back in. It's all good. Okay, this title here is, so you paid cash for your house or land. Do you really own it? Now that's a question that I'm asking because, you know, opposed to what people are taught, it's a lot of different things that go on that people don't know about. So they think that they own, you know, all the little shit they get, and they give the illusion of ownership. And it's really confusing because it stagnates you as a, you know, people to be able to grow and own land and maintain things so that you can govern self. You know, it's real hard to govern self when you govern on somebody else's land. You're going to be paying a tax and things like that. So what I'm going to do with this show here, you know, is I'm going to be talking about land ownership, land title, the warranty deed, a few definitions, and I'm going to put things also in layman's terms like I do so that you can get the concept of what's happening. Now, when you get the concept of what's happening, then you can build on that concept and do your research around that concept, as long as you know what's happening and what you have to do to be able to, possess your land and your things free and clear. So hold on one second. I'm gonna try to stay focused. Sometimes my mind be thinking of other stuff, and then I lose focus real quick. You know, I got a big brain in here and it go all over the place. So anyway, let me just get straight to reading. I'm going to be doing a lot of reading. You probably can't see the screen. If it's any documents or anything that I mentioned that you're interested in, you can go to my website, corporatefreedomgroup.com, and you can contact me on my contact page and let me know if you want the documents. Send me your email. I'll email them to you. You can do your own research and things like that. My book, always got to talk about my book, No Love for Thy Neighbor. It's you can pick it up on my website, corporatefreedomgroup.com as well. I did this book back in 2006. I'm working on another book. I have many sleepless nights, and I'm working on a book and trying to find time. My other book, Headache Word Puzzle. If you want to support this book, it's a puzzle book. You can pick it up at headachewordpuzzle.com. Headachewordpuzzle.com. And I appreciate the support. I appreciate everybody that did pick up the book, the Headache Word Puzzle book, and the No Love for Thy Neighbor book. I really appreciate that. Thank you. All right, let me get to this reading, because I'm gonna be doing a lot of reading. I don't want to kill a lot of time talking, so let me get to the reading. But hopefully you can have your pen and paper ready to take down some of this information, and you have the patience to learn it. All right. Let me make sure I can be heard. If anybody can't hear me while I'm reading, just let me know, and I'll turn it up. And if you got any questions when I go to the call line, this is the call-in number right here. Do not be afraid to call in and ask questions, because it's a lot that has to be sorted out for people as a people. You'd be lost and confused throughout your whole life, and you won't get it together unless you ask questions and learn things. And that's what this show is about, the Sleep Sheep Show, so people can learn things from the show, and it may be a piece of your puzzle. So this is a little link here. A Lloydio land title. Do you own your own property? Many Americans have not come to the realization that their homes, businesses, and properties are collateral on the federal debt, even if you have the deed and is paid for in full. If the federal government defaults on its interest obligations, the private world bankers automatically become the new landlords of every home, business, and property in the United States. Fortunately, our founding fathers realized the importance of property ownership, and there are laws structured to protect citizens against taxes and seizures. Today, over 75% of Americans do not have the highest form of title on their home, business, or property. Instead, they have deeds, which are merely a color of title. To understand how the creditor or bankers qualifies your property, it is essential to understand one legal term. Color is defined in Black's Law Dictionary 6th edition as an appearance or semblance as distinguished from that which is real, a prima facie, a deceptive appearance. Color of title is defined as that which it appears in is title but is not title in fact or in law. And the case that they're citing for that is Wright versus Matron. That's Wright, WRITE versus Matron, MATRON, 18 HOW US 50. Color of title is an appearance of title. Coupled with possession, it purports to convey ownership. This is not to say, however, that it actually conveys ownership. Rawson versus Fox, RAWSON versus Fox, FOX, 65 I11 200. Then you have another case, David versus Hall, 92 I11 85. Did you know that a deed is only a color of title? Deeds constitute colors of title. That's Dryden versus Newman. That's DRYDEN VNEWMAN 116 I11 186. A warranty deed of conveyance is a color of title. Dempsey versus Burns, DEMPSY versus BURNS, 281 I11 644 65 1917. A quit claim is a quit claim deed is color of title. Sanford versus Stubbs, SAFFORD versus STUBBS, 117 I11 389. Thus, any tax deed which purports on its face to convey title is a color of title. Walker versus Converse, 148 I11 622 629. So basically, I'm reading these cases so that you can study, you can take up your own study, you can expound on it, do more research, and you can find a piece to your puzzle. This information is for a selected few, people that desire to set themselves free from an oppressive system, whether it be a unit or whether it be just singular. If you want to start a path or a journey of being free and not, be involved in the melee that they have going on to enslave you, and you want to start doing your own research and studying and learning things. Now, for the record, I'm not an attorney. Sometimes I see people and they ask me, am I an attorney? I'm not a damn attorney. I'm not an attorney. All right. So let that be clear. But anyway, you got to do your own research, and you got to understand that some information, names, and titles are different per state. So, you have 48 or 50 different states, and some of them are unified and some of them are different. So you got to go per your state. If you hear like me say something and you weigh in Alaska, it may be different rules, different, different whatever, different codes and things like that. You got to look it up per your state. And if you having issues with that, you can hit me up on my website, through my website, corporatefreedomgroup.com, and we'll figure all of it out. All right, anyway, let me finish reading. The only true title to land is a land patent. I believe that to be very true. Patents are issued between sovereigns, and deeds are executed by persons and private corporations. That's Lending Fighter versus Country of Gregory. So that's Lending Fighter versus Country of Gregory, 230 NW 2nd District 114 116 1975. A patent is the highest evidence of title and is conclusive against the government and all claiming under junior titles until it's set aside or annulled by some judicial tribunal. That's Stone versus U.S. 67 U.S. 765. The patent, land patent, is the only evidence of the title fee simple title or alloidal title. That's McConnell versus Wilcox, one scam I11 381 396. Issuance of government patent granting title to land is the most accredited type of conveyance known to outlaw. That's U.S. versus Creek Nation, 295 U.S. 103111, and also U.S. versus Creek Nation, 474, Federal Second District, 628634. Aloydo, this is in Black's Dictionary 6. Aloydo, free, not beholding of any lord or superior, owned without obligations. The opposite of feudal. That's Barker versus Dayton, 28 WIS 384, and Wallace versus Harmstad, HARMSTAD, 44 PA 499. Alloidium, this is the definition of alloidium. Land held absolutely in one's own right and not for any lord or superior. Land not subject to feudal duties or burdens, property tax and municipal codes, and an estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. 1 Walsh, real property, 169 CLW, New York, 51118 AM, December 516. All right. It says if you don't have an alloido title on your property, someone else owns it, even if it's paid in full. You owe taxes to the king. All right. So check it out. When I'm citing these cases, and you want to look up these cases, you listen to them, you write them down. You can either Google them, or you can go to like Google Scholar. You put in Google Scholar, you go there, then you search the case through there, or you can go to the Library of Congress. You can go to National Records, National Library. You know, it's a lot of different places you can go look up these cases. If you want actual physical copies, you can order them from wherever they have them at, whoever holds the holdings, or you can do your research online to get the cases if you're looking for the cases. So anyway, when you're talking about you have to have a loyal title, this is what the government, let me go in my book, No Love for Thy Neighbor. This is what the government is saying about your ownership to land when you think you own something. This is Senate document number 43, 73rd Congress, first session. It states the ownership of all property is in the state. Individual so-called ownership is only by virtue of the government, i.e. law amounting to mere user, and use must be in accordance with the law and subordinate to the necessity of the state. So with that session in Senate, they're saying that you don't own, it's mere user. You're just a mere user. You don't own it. So I'm going to try to explain let me put it in layman's terms real quick what they're doing. So let's say you have land. Let's just draw. Let me draw an illustration real quick. Okay. Let me try to get it together. Okay. This is land, right? This could be whatever land you want it to be, a county, a state, whatever land you want it to be. They're going to have a land patent. They're going to have a land patent on this land, right? In that land patent, they're going to have the title. Now, as I read along, you're going to start seeing these things through what I'm reading. This is going to be the title to this whole land right here. So what they do is they break it up in parcels. You're already familiar with this. If you've been dealing with any type of land, they break it up in parcels. It may be 1, 2, 3, 24, 15, whatever number they want to name it. So they break up those parcels. And what they issue with those parcels is a deed, a warranty deed, a warranty deed, a quick title, quick claim, whatever the hell they want to call it. Those are, what did they say it was? Those are color of titles. Those are not real titles. It doesn't express real ownership. So what happens is somebody else still owns it and they let you use it. Whether it's the sovereign state, the sovereign county, the anomaly, whatever it is, they still own it and they just let you use it. And they pretty much fucking with your intelligence. They playing with your head. You know what I'm saying? They undermining you, period. But it's something you can do about it. I'm going to be explaining that too. So just, stick around, take your notes. And then when you get your own time, you study this shit and then you do what you got to do. So anyway, this whole land, this whole big square, it's probably not even an even square. This whole thing is the land title, and they break up bits and pieces. Now, what happens is they give you the deed to get your piece. But what happens is you never claim your piece. So there's a process that it varies per state to claim your piece with the deed. People just keep selling the damn deed and selling it off, and the one owner still owns it. So let's say like they came and they colonized, conquered, and took some land and claimed it under the common law. This is the land they claimed under the common law. So let's say they had somebody went to war and they granted it out to a war general or sergeant. They said, we're going to give you some land after the war. Boom. So they granted him a piece of land. So now he has title. Now let's say he passed it on to his heirs. Now they have title to the land. Now let's say they gave the warranty deed to somebody for them to get title, but they never registered a title. They just kept the warranty deed. Now they sold it. See, what's been happening is the land has been under the color of sale. It's been falsely sold or fraudulently sold to many people, and they're not the real title owner. So what happens if nobody steps up to claim the land, then it defaults back to the heirs, if I'm saying that right. So anyway, if you can get this, it'll be real simple once you start understanding the concept of anytime you buying any land. And also, we're going to break down a few other things. I'm going to commentate as I read. Let me get back to reading because the time don't wait for nobody. Let me get back to reading. All right, I'm going to look up land, definition of land in Investopedia. I'm going to be commentating because if you catch everything that I'm saying, you're going to start understanding, the current condition of things. And once you get it, can't nobody take it away from you. I promise you that. You can only disregard and take it away from yourself. Because we ain't lacking knowledge over here. And you ain't going to hear this probably nowhere else. Nowhere. Okay. It says, what is land? Land is real estate or property minus buildings and equipment that is designed by fixed spatial boundaries. Land ownership may offer the title holder the right to natural resources on the land. The traditional school of economics dictates that land is a factor of production, along with capital and labor. The sale of land results in capital gain or loss under IRS tax laws. Land is not a depreciable asset. I say whatever to that, but let's go down to characteristics of land and land ownership. So it says, in terms of being an asset, land includes anything that is on the ground, which means buildings, trees, and water are a part of land and an asset. The term land is inclusive of all physical elements bestowed by nature to a specific area or piece of property that includes environmental fields, forests, minerals, climate, animals, and bodies of sources of water. There is a wealth of natural resources that may be present on the property of a piece of land that the owner or title holder may be entitled to. This includes plants, human and animal life, soil minerals, geographical location, electromagnetic features, and geophysical occurrences. All right, I don't know if y'all caught that. They just said humans. They said the owner, let me read this again. There is a wealth of natural resources that may be present on the property or piece of land that the owner or title holder, may be entitled to. This includes plants, human life, and animal life. Come on, human life, we're going to start right there. See, this type of thing applies to people that are mindless. They're going to govern you. They're going to take control because they claim to be the owner or the title holder. Hold on, let me look at these comments real quick. Okay, Charles, you said right on time, huh? See, the thing is this is so intricate that unless you study, and then you won't really get a finger on it. So if you're not into this type of thing, then you're just spectating, you know, and that's nothing wrong with that either, because eventually, you know, you may have no choice. But so they telling you that they own you because you're on their land. Now let's go back to this land demonstration that I did, this diagram. If this is the land patent, this is the title, this whole square is the land. You got your little parcel, your little funky ass parcel, and you living on there, and you on this whole shit right here. So this person right here with that title is who owns what you do with that house. They said buildings. So if you build something on it and you don't own that land, you don't own that house either. They own all of that shit. They own it all. So this is what I'm saying. This whole big square for people that's just getting in here is the land patent title. Now within this square, this could be the county of Erie. This could be Chautauqua County. This could be another county, you know, because what people don't realize with the Louisiana land purchase is that stretched across maybe 6-7 different states, but it was all one single land purchase. But that's another topic. Let me finish reading if you caught that. But like I said, they said that human life as well. Human life. All right. So if you're not a human, then you better levitate up off of that land. Because if you on that property, they claiming ownership to you. But notice you got to notice how they word it so you can know, you know, that it's something you can do about it. Anyway, let me finish reading. Let's look at fee simple, which is also called a Lloydal title. In English law, hold on, let me get this together. In English law, a fee simple or fee simple absolute is an estate in land, a form of freehold ownership. It is a way that real estate and land may be owned in common law countries, and is the highest possible ownership interest that can be held in real property. A loyal title is reserved to governments under a civil law structure. So did y'all hear what they said? A lot of people talk about a loyal title. It says a loyal title is reserved to governments under a civil law structure. So what that tells me is that I have to govern myself. I have to be self-governing. That makes me a government within the political system. So when I govern myself, then I can get a loyal title. So if you U.S. citizens want a loyal title, it's not gonna happen. All right. The highest title that they're gonna give you is fee simple, and it's still things that you got to do to get fee simple. But I'm gonna break all that down too. So just pay attention. The rights of the fee simple owner are limited by government powers of taxation, compulsory purchase, police power, and it's cheap. Now notice they say police power. That's what's going on right now. Where you at right now? Every time you see a cop, that shit is under police power because it's being governed for public use. Okay. Recreational public use, which means anybody on that land, you consider the natural resource of that land, and they're going to claim ownership and jurisdiction and dominion over you and everything else. They want to see your title. Okay. And it could be limited further by certain encumbrances or conditions in the deed, such as, for example, a condition that requires the land to be used as a public park with a reversion interest in the grantor if the condition fails. This is a fee simple conditional. All right, let me read the first paragraph, which is wait, I read that. Okay, let me read the history. The history. I might be here longer than an hour because I got a lot to read, but I'm narrowing it down. The word fee is derived from fief, meaning a feudal land holding. Feudal land tenures existed in several varieties. I'm gonna finish reading, but let me say this. This is a definition on Wikipedia. That's fee simple. Go look it up. Go read it. Read the whole thing. I'm only going to be reading portions of things. And like I said, if it's something that you want that I'm reading, you can email me through my website, corporatefreedomgroup.com, and I'll send it to you. Most of which involves the tenant having to supply some service to his overlord, such as night service, military service. If the tenant overlord was the king, grand serjeanty, then this might require providing many different services, such as providing horses in time of war or acting as the king's ceremonial butler. These fiefs gave rise to a complex relationship between landlord and tenant. See, this is where when they try to draft Muhammad Ali into the war, that was under civil service something. They call it civil something. I can't think of it right now, but they were doing that under that, which was basically saying that because you live in the country and you were a citizen, that we can call you to draft you to war anytime we're ready. Or we can take whatever we want, easement for government use and things like that. So, for example, in return for receiving his tenant's fealty or homage, the overlord had a duty to protect his tenant. When feudal land tenures was abolished, all fiefs became simple, without conditions attached to tenancy. Now, this is about somewhere where the Constitution came in, and they didn't allow, the troops to quarantine your house without permission and things like that. Let me keep reading. Common law. In English common law, the crown had radical title or alloitum title of all land in England, meaning that it was the ultimate owner and all land in the past feudal, of all land in the past feudal era. However, the crown can grant ownership in abstract entity called an estate in land. Let's go back to this. That's what these are. if the king had this whole square, they granted estates and land and called it parcels and gave deeds for those parcels. Now, the people that were properly educated in property law, they would take that deed and they would make their own claim to say this part right here is my land. This is no longer under this whole land thing. So now it would just section it out. So if somebody smart enough with a deed would take it and register the title and claim that, then it would only be this section. And this little section right here would be the District of Columbia. You see what I'm saying? The District of Columbia would be this little section, and this would all be the rest. All right. So whoever owned the District of Columbia, they were smart enough to take that 10 square mile radius and start some federal government and contract with the other states, some shit like that, because they have their own. And also New York City, a few of them. New York City, it's a few of them. I can't name them all. I can't think of them all. But you know, when you hearing this stuff, you'll see the semblance, the resemblance in what they're doing as I'm reading it. So let me finish. Which is what is owned rather than, which is what is owned rather than the land it presents. So they saying that when they issue this deed, they saying that you only own the deed. You don't own the damn land that it presents. You only own the deed until you make that claim. That's what they saying. So that's what's happening now. Everybody getting these warranty deeds and they recording them at the county and they think they own it because they recorded at the county. It's a whole nother process. That's only half the battle. We're going to get into that too. So stick around. All right. The fee simple estate is also called estate and fee simple or fee simple title. And like I said before, this could be different in different states. It could be a loyal title in one state, fee simple, and something else in another state. You got to look for the concept and look for it in whatever state you're in. Sometimes simple freehold in England and Wales. See, they talk about the common law, England law, but that's what's over here in America right now because it was the colonies that turned into states. They carried the same law and they applied it here. So it's really not much a difference. From the start of the Norman period, when feudalism was introduced to England, the tenant or holder of a fief could not alienate, they saying you couldn't sell it from the possession of the overlord. So if the land patent is held by the state or the District of Columbia, they're considered the sovereign overlord. And they're saying that the tenant, the holder of the deed, couldn't sell the land from the possession of them. They couldn't do it because they didn't have the title to do it. They only had a deed. Okay, let me see. A process known as sub enfiofing and sub and whatever. It says the 1290 statute of quia importis abolished subfeudation and instead allowed the sale of fee simple estates. Now this is when people start claiming the title. When you claim the title, it's a title. You have a deed and you have a title. Most people confuse the deed with the title. When you have the real title, you get issued a certificate of title to that land based on a land patent, not a warranty deed. All right, let me finish reading. Like I said, I'm gonna skip a few things and I'm gonna just, you can look up the definition, read the whole thing for yourself. It says an estate and fee simple denotes the maximum ownership in land that can be legally granted. It is the greatest possible aggregate of rights, powers, privileges, and immunities available in land. The three hallmark of fee simple's estates are that it is alienable, divisible, and descendable. Now you got to ask yourself, do you have any of that? Do you have that maximum ownership in your land, or do you just have a deed? All right, you can read the rest of that. A lot of interesting stuff in there, but I'm gonna keep it moving. So anyway, in the event, let's say you got your warranty deed. Now what I'm saying is this too. Let me say this too. Let me put this disclaimer out there. Don't just go acting on what I'm saying. Do your study per your state, and when you're ready, you make your moves. You make your moves, because I'm not liable for the mistakes that you make. You know what I'm saying? So let's say you have the warranty deed, and you want to really own the piece of land that you have. Now, like I was saying, you can own the house, but if you don't own the land, then you still don't own the house, because whoever owns the land get everything on that land. That's why you have parking meters and taxes and things like that, because they want to keep paying the people who own that land. So that's how they generate revenue. You got to remember, the government doesn't print revenue. They don't print reserve notes. And especially if you're buying stuff with reserve notes, which is a promissory note, that's a whole nother topic. But you definitely don't own it. All right, so let me go ahead and continue. Now, this here was a letter from Texas, from the General Land Office. This was an actual letter of a case that I was actually involved in, or a situation I was actually involved in. So let's say you have the deed and you want to request for a patent, because you're going to need a patent. You're going to need a patent. Now, this is from Texas. They could have different processes from any other state. I don't know, but I'm going to read this one here from Texas. And this is a case that I was actually involved in, or let's just say a situation. So, state of Texas General Land Office, patent request requirements. So they have requirements to request a patent. This is you taking the steps to really own some shit and not just be a tenant in fee simple or whatever. So the following are required for each patent request. And like I said, this is state of Texas General Land Office patent requests. Some states, they have General Land Office. Some states is called Bureau of Land Management. And some states, their office cover other states. So you got, it's real tricky. So they may have one General Land Office that cover 5 different states. They may have one General Land Office that cover one state. It may not be called General Land Office. It may be called something else. I think in New York it's called something different than the General Land Office. So you got to look up what it's called. All right. Give me a second. Got to get my focus juice. All right. So the following requirements for each patent request. The purchase price, that's number 1, the purchase price of property must be paid in full. Paid in full, they talking legal tender for all debts, public and private. All debts, public and private. That's number 1. So that means if you have a mortgage, you just hold her in due course. If you are renting, even if you don't own that land, then it's not paid in full. It's not paid in full. So you're not going to go to them and say, I want the land patent, and you sitting there on a mortgage. They gotta release that deed to you. So anyway, without a lien on it. So anyway, number 2, a written request for the issuance of a patent addressed to the Texas General Land Office by the owner of the land or his authority, agent, or representative. So they saying they want you to write them a letter requesting for them to issue a patent. That's real self-explanatory, real simple. A letter by the owner. So you have to be the owner of that land. And this is from the horse's mouth. This ain't me making this shit up. 3, proof of ownership. They want, i.e., a deed, judgment, affidavit of heirship, etc., together with $25 filing fee for each document. So they want some type of ownership. It can be an affidavit. It can be a judgment. It can be a deed. They want proof of ownership. Now a deed is, let's look at deed. Let's look at what a deed is, or a warranty deed. Let's look at this. Let's read this. Yeah, I think I'm gonna make some more time so I can finish this reading. Okay. Warranty deed, a deed that guarantees a clear title to buyer of real property. Okay, so it says a warranty deed is a type of deed where the grantor guarantees that he or she holds clear title to a piece of real property estate and has a right to sell it to the grantee. They're not saying that it's clear title. They saying that it's a guarantee of a clear title, not clear title. So that tells you right there through the definition that it's not a damn land patent or a title. So anyway, let's go back to what they talking about. So they want proof of ownership, and you may have these things. So that means that you got to get it going. Okay. 4, field notes describing the tract of land on which the patent is to be issued. See, I'm sure the District of Columbia knew that the field notes for the patent land was a 10 square mile radius. Okay, with the required $25 filing fee. Plat and report prepared by a licensed state land surveyor, that's LSLS, or county surveyor of the county in which the land is located, if required. Field notes by a registered professional land surveyor cannot be accepted. RPLS. Before forwarding field notes to the GLO, they must be recorded in the county surveyor's record for each county in which the survey is located, and the file stamp original forward to the GLO. See, this is what's happening. People are recording it in the county and they stopping right there, and they thinking that's it, because nobody's telling them. Your lawyer's not telling you. Nobody's telling you the full process to own that land, because they don't want you to own it. They don't want your ass owning nothing. Like they said in my book, it's all mere via illusion. It's an illusion. It's not real ownership. That's what they said. So anyway, I'm going to read that again. It says that you can't let a registered professional land surveyor survey your land and bring it to them. They're not going to accept it. It has to be from a county surveyor or a licensed state surveyor. It says before forwarding that to them that you have to have it recorded in the county where the land is located. File stamp original forward. You have to have them file stamp the original and forward it to the GLO, the General Land Office. And then it says a patent will be issued in the name of the original grantee of the land or his or her successor or assigns. See, most people don't even know what successors or assigns are. They don't even know what heirs are. They don't know any of that. Descendants, they don't even know what that is. For a patent to be issued in the name of the current owner, an applicant must, so they saying if you're the current owner, submit a certified copy of each conveyance from the original grantee down to the current owner with a statutory filing fee of $25 for each deed filed. Now, what they're saying is this: a statutory conveyance, a certified copy of each conveyance. they're saying, let's go back to my little illustration. When the sovereign state had the land, they conquered, did whatever by conquest. They took the land, they granted it to one of their war generals, and they granted it to their successor or their family or in trust. And they're saying that when they gave it over and they claimed title, and they gave it over and they claimed title, and they gave it over and they didn't claim title, they just registered the deed with the county, and they gave it over, registered the deed with the county. It stopped at the last person that claimed title, which could be 100 years ago. It could be 200 years ago. However old it is, you got to look through the record and find that record and say, this is where you claiming it from. So if this person 100 years ago has any heirs or any successors or anybody that's going to fight, you're going to have to make the claim against them for that land. You're going to have to bring it in a district court for that land. This is how you're going to get your land title. We're going to get into that too when I'm done with this. And then I think I'll be done after that. So then it says that, then it says, or submit a title opinion reflecting the chain of title. See, right here is where the chain of title was broke, when you got 3 people, 4 people that did the title, and then you got everybody else up to date that didn't do anything. They just had the deed and registered with the county. They broke the chain of title. So people that sold it in between, it was fraudulent, a fraudulent sale. They never sold it with a proper title. They sold it with just a warranty deed. They never really had the proper title, so it really wasn't a valid sale. Okay, chain of title of the name and address of the current owner with a certified copy of the deed into the current owners and statutory filing fee. So anyway, yeah, that's it for that. So anyway, they like I said, if people claim the title, and then you have nobody that did the title in over 100 years, and you only have people that did the warranty deed with the county, then you would be only getting the 3 land patents from the 3 original people, and then that would be $5 a piece for each one of those if you're dealing with Texas. And then you would come with the 4th one and say, this is where I'm making my claim at. So that's you'll be registering that title, recording it under they call it a race, like where you racing first come first serve type thing. But we're gonna get into that too. Let me read this. I said I was gonna be doing a lot of reading, but this is for the people that it's for. They're gonna be able to do the research and get it. Let me check the comments. Peace to everybody in here saying peace to me. I'm trying to catch you and I'm trying to read. If you have any questions, like I can answer them quicker if you just call in when I'm done. Call in this number and ask your questions and we can sort it out. All right. Let me see where we at. Okay. It says Recording Act. The vast majority of states in the United States. No, we're not even going to read that. We're not going to read that. Oh, wait. Okay, this is what we're going to read. Title searching. A grantee title search attempts to locate records by searching the parties listed on the recorded instrument. One approach to conducting a full grantor-grantee title search starts by searching the grantor index in the county records and determining the name of the first recorded owner of the title. The first recorded owner of the title. That's where the title starts at, and anybody after that is called the chain of title. This is usually the sovereign, which is the federal government or the crown of the nation, which owned a former colony now located within United States. Did y'all catch that? They saying that the original owner was the federal government or the crown of the nation, which owned a former colony now located within the United States. So they saying somebody in England, this is what I talked about before, somebody in England still owns that land from their their expedition when they came and conquered and set up their counties and things like that, and colonies and things like that. The search finds the grant from sovereignty to the first grantee. This is usually in the form of a patent. Then the grantee's name is searchable in the grantor index to find the deed by which it has subsequently conveyed the title, and so forth until no more grants are found. Liens and encumbrances granted by any of the parties shown on record instruments are also found in the search. Though theoretically accurate, this approach has practical difficulties due to there often being numerous grants from the sovereign. So when they say numerous grants, they're talking about this whole thing is what they own. And these parcels are the numerous grants, the deeds that they issued out. So you may go to look up your shit, and then you may see this whole thing right here and be like, damn, my shit is all y'all shit too. You better claim yours, because everybody else ain't gonna claim theirs. Therefore, an alternative method is to reverse the process, i.e. to search backwards in the grantee index. This is done by beginning with the name of the person or entity who is thought to own the land to find the grantor to it. Then the grantee index is searched again to find the source of that grantor's title, and so on until you reach the grant from the sovereign. The linkage from grantor to grantee are called the chain of title. The last grantee found is the record title holder. So this is what you have to, go to the general land office with. You have to have this whole chain of title from the grant, from the sovereign, all the way into you. Okay, let me finish reading this. Let me see how the system works. The record title holder is not necessarily the actual owner of the land. If there are previous unrecorded deeds to it, to others, the principal legal theory is that once a person has conveyed the title to his or her property or some aspect of it to someone, he or she has nothing left to transfer to any subsequent person. However, as a result of the various states' recording act, the court will protect a bona fide purchaser who pays valuable considerations and doesn't have knowledge of the prior unrecorded deed from the claim of a prior grantee under that deed. The same is true respecting most types of unrecorded liens or encumbrances. For example, purchaser of the land from the record title holder who pay valuable consideration and have no knowledge of unrecorded mortgages will be protected against those mortgages by the courts. All of this flows for the statement in most recorded statutes that are unrecorded instruments are void against such purchases. I feel like what I'm reading is kind of just, it's not even necessary. Let me go to something else. Effect of Recording Act. Each U.S. state has Recording Act, a statute which dictates the legal procedure by which an individual claiming an interest in real property, real estate, formally establish their claim to that property. The recordation of property rights becomes particularly significant where an unscrupulous dealer in land purports to sell the same tract of land multiple times. So that's one of the reasons why they have the title registration, so that whoever registers the title is considered the owner. So they even said that the title holder is not necessarily the actual owner of the land. So just because you hold the title you still have to register it to prove that you're the owner on the record. So let me see where I'm at. Okay, with other kinds of property, the first buyer would be the owner of the property, and later owners would have no interest in the property and would instead have a cause of action against the original seller for fraud. With real property, however, the first buyer is not necessarily the owner, depending on the kind of statute under which the recording of such property interest operates. There are three basic kinds of statutory schemes and recording acts: race notice and race notice. Even though a recording act does not require recordation, the law does create strong incentives for a buyer to record. Recordation provides constructive notice to any subsequent purchaser that a prior conveyance occurred, and therefore protects the prior purchase in the event of a subsequent conveyance. And then they have, you can read this. I'm going to skip this because I'm ready to keep it moving. It's called race status, notice status, and then it's race notice status. And basically, to sum it up, it's saying the race status, which is in certain states, is whoever makes it to the recording office first, then they own the land. Notice status is whoever makes a notice, or whoever is put on notice. And if they're put on notice and they don't go to the recording office or fight against the notice, then they lose the land. And race notice is either one. You can read it. It's called recording, and it's real estate, recording real estate. And you can read that. I'm gonna keep it moving. I'm getting hot. Let me turn this fan off. All right, we're gonna keep it moving. We're gonna talk about registration of land title, so you can have a concept of how the land is registered. And then with that, we're gonna talk about writ of ejectment, which is when you do all this and you get your title registered and you get your decree, and then you want to eject, any trespassers off of your land. Charles, what is the land patent? You can look up the definition of it on Google, but the land patent is the metes and bounds of the property that you're claiming. Like if they say 10 square mile radius in the District of Columbia, then that's going to be the 10 square mile radius. There's going to be the land patent. It's going to be, you ever seen like, people with tripods and the yellow jackets on, and they pointing that little thing that they measure in the land, you know what I'm saying? And all that. They used to have it where they used to roll it and measure it. Now they got these little things that they can, little lasers, they can reflect it and all that to measure the land and do the land patent to survey the land and things like that. So let me get into reading this right here. I'm going to read a few things in here and probably one more thing, and I probably could be out of here by 8:30. I'll be gone. All right, let me see. This is registration of land titles. This is from 1905. And this is from Minnesota. Let me see. Revised Laws, Minnesota. What did I say? 1905. Okay. Let me see what I'm reading. Okay, 3379. Let's go to 3379. Have y'all pen and papers and write this stuff down. Okay, application to what court? I'm going to skip a few things in here. If you want this document, you can email me. You can email me or you can contact me through my website, corporatefreedomgroup.com. I'll send it to you. Application to what court? Power of court. So this is basically going to tell you what court you're going to be filing this in. An application for registration shall be addressed to the district court. They said district court, so you got to search your district court and wherever you at. All right, that's simple. And for the county wherein the land described they're situated, the district court shall have original exclusive jurisdiction thereof. of all proceedings thereunder, and shall have full power to inquire into the title of said land, and any right, title, interest, or estate therein, and any lien, charge, or encumbrance thereof. By its decree, it shall adjudge and determine the title to said land, the nature, character, extent, and amount of all liens and encumbrances thereof, the priority as between the same, and shall remove all clouds from the title. Now, the cloud on the title is basically the liens or any other person with interests, mechanics, liens, whatever. The district court shall have the full power and authority to make all necessary orders, judgments, and decrees, and for these purposes, the court shall be always open. See, the court always open. I don't know how many people have been keeping up with things I've been doing, but I did have a time where I went to court Sunday night at 3 a.m. Literally, it's crazy. I'm gonna take this call. Let me see what. Peace. Hold on 1 second. Let me make sure I can hear you. Go ahead. I can't hear what you say. The hell? Okay, there you go. What's up? Can you mute or turn down what's in the background? Me too. Okay. All right.
Hello?
Yeah. Go ahead. I can hear you.
All right. No, so like when you talk about the patent, when can you file for a patent? Can you file for a patent if you don't have the title or the deed, or you gotta have the title or the deed to register a patent?
They see what they was saying was either or. So you can have an affidavit, because you can acquire land in many different ways. You can get abandoned land. They say through conquest, through purchase, through gifting, things like that. So depending on how you get it, you're going to have some document that's going to make a claim to it, or you're going to have somebody claiming that they passed it to you. It's going to be some type of conveyance document. And that's the document they want to see. You know what I'm saying? But you can do an affidavit and state your claim and go in there with that affidavit. Now, if you bring that case and don't nobody step up with a real title or rebut your affidavit, you know what I'm saying, with some evidence, then you would suffice in your claim.
Okay. So like how the agency have their own patent already. Like just say like it was a previous owner and he did his patent and it was registered.
Right.
Just say he was delinquent, he left his property, whatever, it was delinquent.
All right, check it out. They have, per state, they have different statutes or rules or laws which determine the time of abandonment. So they may say 5 years in some states, 10 years here, 20 years there. So if it's abandoned for 5, 8, or 20 years, depending on that state, then you got to make that claim. You can't assume that they know that it's been abandoned for 8 years. So you got to prove that it's been abandoned for the amount of time that you said, which is why you did acquisition or whatever you did to take that property.
Okay, so you do a patent on it, or when is it good to do a patent?
Man, anytime. Can nobody stop you from doing a patent? When I read for Texas, they were saying you got to do the survey. Okay. So you determine according to the last, you look at the chain of title and see what their survey was. And then you take those and then you say, you want this surveyed currently. You know what I'm saying? Okay. Or if you want, this is stepping out there, you can survey the whole patent, from the original, not the deeds for little parcels. You can survey the whole portion, maybe 1,000 acres, maybe 2,000 acres. I don't know. But, okay, what's going to happen with that, or you can just survey your portion. What's going to happen with that is you got to, I was going to get into that here, but you got to put everybody on notice. You know, the United States, everybody who's claiming an interest, the county, anybody, and they will have to come in. Go ahead.
So when you try and make a claim, is it good to have your own patent and everything to make your own?
Of course, because you make your patent, and then what you're gonna want to do is what I'm going to be getting into. You're gonna want to go to court over that patent and then register it in the land title. And what's going to happen if somebody just had the deed, and then you come in and say, I have my title registered with the land, you're going to have a superior title to compared to their deed, which is unregistered. It's only recorded at the county, but it's not registered in the general land office. See what I'm saying?
Okay, so let's say you're in a foreclosure. When can attorney?
The thing with the foreclosure is, it's still a lien from the beginning of the mortgage. It's a lien on the title or the deed or whatever. They're gonna have some type of lien or something. So you don't own it outright. You know what I'm saying?
So can an attorney represent the bank or anybody, or what kind of attorney
attorneys can wipe their ass with razor blades. No, I don't know what attorneys do, man. They can do whatever they want, allowed by the law that they under. You know what I'm saying? The Bar Association, okay. But I don't keep up with what they do. You know what I'm saying?
So attorney could in the bank anytime they want to when they don't.
Well, the attorney is not going to come in and represent himself in any matter. He's going to have clients, and they're going to be on their behalf. You know what I'm saying? But they
gotta have some kind of interest.
They don't have attorneys don't have first-hand knowledge, and you know, they can't make first-hand knowledgeable statements other than the documents that they may have signed to attest just that document, or if they witnessed the document, but they can't make no first-hand knowledge.
So you're telling me, like, if I went through a bank, like if I went through a bank and I'm in default, whatever, they could hire an attorney to represent them?
Yeah. Yep. They always do. They have some of them already have legal departments already signed up for that.
Okay.
They don't just go looking for attorneys after it happened. They already have them ready. They done been through this plenty of times. You know what I'm saying?
So what about private? Like, just say you're not dealing with the mortgage or anything like that. You just dealing with the individual, the owner. Can he represent?
It's going to be when I talked about the recording, the race. It's going to be whoever registered the title first and have the title in hand.
Okay.
And whoever's able to prove it. So, like I said, if he got a deed and he had the deed, but he never registered the title, he don't own it. You know, it's still like. Okay. Go ahead.
What you mean by register? Like, cause like.
Well, that's what I was talking about now. You want to sit back and let me finish going, or you want to keep talking? What you want to do?
No, go ahead, brother.
All right, so I'm gonna put you on mute. What you gonna do? You gonna hang up, or you gonna put you on mute?
No, I'll be on mute. Go ahead.
All right, and just come in when when I'm done.
I got you, brother.
All right. Okay. All right. So where you going to be bringing it's called a quiet title action, to quiet the title, because you want to quiet the title and you want to register the title, register the land. So anyway, the district court shall have the original jurisdiction and they shall always be open. I read all that. I talked about how I actually went to court on a Sunday. That shit was crazy. On a Sunday at 2-3 a.m. in the morning. I didn't know what the hell I was doing, but it worked. And I went to court. That was the craziest shit I ever experienced. That's when I knew that I was on to something. And I'm not giving up. All right, anyway, let me finish reading. Order for summons. Let me see, that's 83. Let me finish reading. Okay. He shall ascertain whether or not the land is occupied, and if occupied, he shall assert the nature thereof, and by what right the occupation is held. Oh, wait, let me see. Am I at the right damn spot? 383. Okay, that's for the examiner. Okay, I'm at the wrong. Here we go. And they're saying that they're going to appoint an examiner to, help you out to investigate, the status of the land and things like that. And they're saying they're going to ascertain if anybody else is occupying the land and, what's their reason for occupying it, and do they have any documents or anything like that. That's what they're saying, So anyway, order for summons, parties, defendant. If, in the opinion of the examiner, the applicant has a title to the land proper for registration. So remember when you requested the patent from the General Land Office, you had to go through that process, which I explained, to get the patent. And then they issue you a certificate of title. Now, once you get that title, that's not registration. Then you have to register that title. So anyway, in the opinion of the examiner, the applicant has a title to the land proper for registration, or if the applicant, after an adverse opinion of the examiner, elects to proceed further, the applicant shall file with the clerk a verified petition praying that the summons must be issued in said proceedings. The court shall thereupon examine, and the files and records in said proceedings shall be its order, direct that a summons be issued therein. This order shall contain the name and address, so far as known, of every person who is to be joined as a party to said proceeding, including all persons named in the application or found by the report of the examiner to be in possession of the land, or as having any right, title, interest, or estate therein, or any lien or encumbrance upon or against the same, together with the same and address of all other persons or parties whom the court has said order may direct to be joined therein. These parties thus named in the order of the court shall be known as defendants. So what they saying is that the examiner is going to help you look for anybody that has any other interest in the land. If you have any heirs or anything, you're going to have to name them as plaintiffs on your side, and then anybody else is going to be defendants. So let me finish reading. Form of summons. The summons shall be subscribed by the clerk and shall be directed to the defendants and require them to appear and answer the application of the applicant within 20 days after the service of the summons, exclusive of the day of such service. It shall be served in the manner now provided by law for the service of a summons in civil actions in the district court, except as herein otherwise provided. It shall be served upon the state by delivering a copy thereof to the Attorney General, who shall transmit the same to the county attorney of the county in which the land described therein is situated, and thereupon such county attorney shall appear in such proceedings and represent the state therein. See, what they saying here is even the state, they're showing their interest, because you have to serve it up on the Attorney General, who serves it up on the county. So that shows that their delegation of authority. So when you serve the state, they serve it on the county, they're going to have to come in and defend as well as any other defendant. So if you do this and you win this case against the state, then who else going to come and ask you for taxes? The county. Who else going to ask you for taxes? Just the fact that they can be exposed by you filing this and they have to defend it, it shows the chink in their armor. This is their Achilles heel. So you really gotta, you gotta study these things and then you start applying them. Hold on one second. I'm gonna get right with you. See, give me a second. Private versus public. See, the money, what a reserve notes is legal tender for private and public. All right, let me finish reading this. Let me see where I'm at. So they said, like I said, you got to serve the state as well, and they send somebody from the county to represent the state. It shall be served upon all persons who are not residents of the state, and upon all other persons or parties unknown claiming any right, title, estate, lien, or interest in the real estate described in the application herein, by publishing the same in a newspaper, printed and published in the county wherein the application is filed, once each week for 3 consecutive weeks. The clerk shall also, within 20 days after the first publication of the summons, send a copy thereof by mail to all defendants who are not residents of the state, and whose place of address is known to the applicant or stated in the application, or in order directing the issuance of the summons, the certificate of the clerk that he has mailed the summons as herein provided shall be conclusive evidence thereof. Hold up. Other or further notice of application for registration may be given in such manner and to such person as the court or any judge therefore may direct. The summons shall be served at the expense of the applicant, and proof of the service shall be made in the same manner as in civil action. The summons shall be substantially in the following form. So they're telling you how the summons shall be. This is how they say to write the summons out. Summons and application for registration of land, the state, the county, district court, judicial district. In the matter of the application of your name to register the title, so you register the title to the following described real estate. To the following described real estate situated in whatever county, whatever state, namely description of land, which is going to be the survey, name of defendants. You're going to name the defendants. That's how you name the defendants. All other persons or parties unknown claiming any right, title, lien, or interest in the real estate described in the application herein. That's how you name the defendants. The state of Minnesota, to the above named defendants, you are hereby summoned and required to answer the application of the applicant in the above entitled proceeding, and to file your answer to said application in the office of the clerks of said court in said county within 20 days after service of the summons upon you, exclusive of the day of such service. And if you fail to answer the said application within the aforesaid, the applicant is proceeding will apply to the court. The applicant in this proceeding will apply to the court for the relief demanded therein. Then it says witness, clerk of said court, and the seal thereof, and the date or whatever. Okay, now it says when the summons has been served as herein provided, the court shall be deemed to have acquired jurisdiction of the subject matter of the proceeding and of all persons whatsoever who have or may have any right, title, interest, or estate in the real estate described in the application, or any lien or charge whatsoever upon against the same. By the phrase in the summons, all other persons or parties unknown claiming any right, title, estate, lien, or interest in the real estate described in the application herein, all the world are made party defendants and shall be bound and concluded by the decree. So what they saying is basically you got to sue the whole world. You got to sue everybody. They're saying by you doing that, you make all of the world defendants. Everybody is a defendant. So that means anybody have to step up and make their claim as well, equally or surpasses yours. You know, it may be two brothers who has heirship to the land and maybe, claiming superior interest. So they may step up and say, hey, I have equal interest, or, you know, whatever. But I think that's deep when they telling you to make the whole world defendants by that statement. And then you bring this case and you notify the state, and they're going to have to come fight on a county level. They're going to have to come fight as well for that land. So now it's a land fight. Now what's going to happen is you're going to learn a lot from this. You're going to learn if you can win. If you lose, they're going to tell you how to beat them, because they have to. They have to tell you how to beat them. Or they're going to tell you that you don't stand a chance in France. You don't have an army big enough to defend this land. You know, they're going to tell you something. Anyway, let me read a few more things and then I'm done. Any person claiming any right, title, estate, or interest, or lien upon the land, whether named in the summons or not, may file an answer therein within the time named in the summons, or within such further time as may be allowed by the court. The answer shall state all objections to the applicant and shall set forth the right, title, estate, interest, or lien claim by the party filing the same, and shall be signed and verified by the defendant or by some person in his behalf. Okay, decree on default. If no person appears or answers within the time named in the summons or allowed by the court may at once, upon the motion of the applicant, no reason to the contrary appearing, and upon satisfactory proof of the applicant's rights thereto, make and file its order and decree confirming that the title of the applicant and ordering the registration thereof. Then it says the decree of registration, the effect. It says, I'm gonna read this and I'm done. If after hearing the court finds the applicant has title proper for registration, whether as stated in this application or otherwise, it shall make and file its decree therein confirming that the title of the applicant and ordering the registration thereof, except as herein otherwise provided, every decree or registration shall bind the land described therein and shall forever quiet the title thereto, and shall be forever binding and conclusive upon all persons, whether mentioned by name in the summons or included in the phrase, all other persons or parties unknown claiming any estate, right, title, lien, or interest in the real estate described in the application herein. And such decree shall not be opened, vacated, or set aside by reason of the absency, infancy, or other disability of any person affected therein by, nor by the proceeding of law and equity. They basically just saying you're going to quiet that title forever. That means you can pass the land down, everything on the land, and you can, build your empire. So anyway, let me go back to the line. All right. You there on the line? Let me see. The own everything above, below land, human is. Okay. So basically, if you're going to do this, you really got to be smart about it. You got to study. You got to learn what you're doing, network with other people, and then put it in trust. Don't put it in your name, put it in trust, and you make yourself or somebody else the trustee and the beneficiary, things like that, and then you pass it down for generations to come. You know what I'm saying? So I think I read enough. Go ahead, man. Go ahead. Let's talk.
Okay, so when you were saying that you got to put everybody on notice, how can you put everybody on notice?
Well, they just said it. They were saying it right here in this law. Like I said, we're looking for the concept of this. So if it doesn't say this in your particular city, this is out of Minnesota. This is what it says in Minnesota. You start looking up where you're at, seeing what the process is there. You see what I'm saying? So what they said is by you filing it with the clerk, and I read the actual, thing that you're going to file. They're saying you make them defendants by saying all other persons or parties unknown claiming any right, title, estate, lien, or interest in the real estate described in the application herein. So that makes the people that you know are claiming interest, you put them in there, then you put all other people, and they say that makes the whole world defendants. So somebody in this world has to step up to say, I have an interest in that property as well, whether it be the county on the state's behalf, whether it be somebody else or somebody from England or wherever. That's why it's the whole world, because they way over in England owning this shit, and they never had to defend it. They never had to defend it because nobody ever did such a process to threaten them to defend it that I know of. You know?
Okay.
This is something, man. This is intricate. You know, it ain't nothing that you could just, you know, it ain't nothing instructional. It's real intricate. So you really gotta.
Right. So is it good to file, like, just say anybody who's dealing with a foreclosure? So anybody can file a quiet title when you're dealing with foreclosures?
If me personally, if I go buy a house and get a deed with a lien on it, you can claim superior title by, you know, going after the title, the land patent, doing a land patent, going after the title against whoever sold it to you. You know, so
Okay.
It depends, but they said that it had to be paid in full. So it's going to be a lot of questions around did the bank pay it in full, or whoever else paid it in full, you know, the loan. It depends. The bank, they generally just giving you a loan on account of, you know, you paying somebody else for you to get the property, you know what I'm saying, without having to pay the full price. So they just giving you a loan for the property, and they use the property as security interest. So if you don't pay them back the loan they gave you, then they come after the property. That means they put a lien on the property for the amount that you didn't pay them back in Federal Reserve notes.
Okay. So is it good to file a list of pendants to put everybody on notice?
A list pendants? It depends if that's the process. According to what I'm reading here, if that's the process, it may or may not be. I'm not sure.
Okay. Depends on your state and your law.
It depends on the process, you know, according to the concept that I mentioned.
Okay.
So this is why you really got to study. You know, we can have time to build on this and look into what state you in, and, you know, figure out the flow there. But it's a lot of things that I read that has to be in place before you go after these things. And if you don't have them, and it's only 2-3 ways to get them, and you can't facilitate those 2-3 ways, then you probably won't get it. You see what I'm saying?
I got you, God.
Okay.
I ain't gonna hold the line. I'm gonna let somebody else talk.
No, it's cool, man. It's cool. I'm gonna take one more caller, and then I'm gonna go ahead and get up out of here. Where Hollywood at, man? 10 o'clock. Man, I ain't got that much wind, man.
We need it now. All right, go ahead, brother.
All right, I appreciate you calling, man.
All right, peace to God.
Peace. All right. So I'm gonna stick around for a little bit. I'm gonna take one more caller. Hollywood, where you at, man? Come on in. Let me here go the call-in number right here for anybody that want to call in with any questions. I swear y'all be scared to ask questions. Y'all probably don't know what questions to ask. Crazy stuff I'm talking about. Kim, what's up? All right. Angela Simmons. Chris, peace to the God. Okay, Prince Moreno. I think if I'm saying it right. I already talked about, you know, how to attain title. You just got to listen back to the show. It's going to be on YouTube at Uno Self. And, you know, y'all go to YouTube. If you're not subscribed to my YouTube channel, go ahead and subscribe, because I'm going to keep dropping videos as much as I can. And earlier I tried to do this and I got shut off, but I came back in. Okay, it's a lot of comments there. I can't really keep up with them all. But okay, you don't. Okay, let me see. You don't own it unless it's in an irrevocable trust or you have changed your status. Okay. Okay. All right, I think I'm gone, man. But check it out. Let's say, for instance, right? I'm gonna point out a cold situation. Let's say, for instance, Malachi Z. York. He had a situation. I read up on his story where he had some land. I think it was in Georgia, and the county who sued him. The sheriff sued him because they had an interest in that land that he was building on. So they sued him based on the building codes. They say, "Oh, you building some pyramids on this land, and we don't like your pyramids or your message or nothing you doing, and we gonna come in and sue you based on these building codes." But now, if you know, if the right moves were made, then they could have came in and said, "Oh, these buildings is my property. I have a right to property. So you violating the Constitution, denying my right to property, my right to build, which is repugnant to your building codes." And there's a case already out there where somebody already did it. You got to do the research on it. Already built something. They said this is a violation of the building code. They took his ass to court. He said, "This is damn your building code. This is my right to property. So you deny my right to property," and he won that case, and he built whatever the fuck he wanted on his land. So when they came in and knocked down all those beautiful pyramids and things like that, if the proper paperwork or proper process was in place, I don't believe that any of that would have happened. You know, they've been doing this shit for a long time. They know where to expose you at, and they're going to keep exposing you till you start waking up and start fighting the fuck back. And with that being said, I'm out of here. So y'all enjoy y'all day. Thank you for tuning in, or enjoy your night. Thank you for tuning in to the Sleep Sheet podcast, and tune in next week. You know what I'm saying? Get this information. Listen back to this. Go to YouTube, like it, subscribe, and I'm going to keep putting out this information. It's going to be up to you whether you want to pick it up, build your tribe, or whatever you're trying to build, and start putting this shit into play. Or they're going to keep chewing your ass up in these courts. Because I ain't here to play with them. I ain't here to play with none of that. So I'm gone. Peace to the gods. Babylon, whoa. Blood suckers. Vampires. Hold me down for more than 400 years. But I overcome and conquered all of these. They might try hold me down for more than 400 years. But I overcome and conquered the wears and tears. So long.